Good morning. I hereby call to order this 20th and final meeting of the Pennsylvania Public Utility Commission for the year 2016, and I ask that you please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. First matter on this morning's agenda is the approval of the minutes for the meeting of November 9, 2016, and I will recognize Commissioner Sweet, who is the editor.
Madam Chair, I've reviewed the minutes of the public meeting of November 9th, 2016, and move that they be approved as submitted. Thank you.
You have heard the motion of Commissioner Sweet to approve the minutes. Is there a second?
Second.
Second by Commissioner Powelson. Any discussion? Any edits? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. Now we will go on to our agenda and call up our Director of the Office of Special Assistant, Cheryl Walker Davis, to lead us through this morning's agenda.
Thank you, Madam Chairman. Good morning. Good morning, Commissioners.
Good morning.
May it please this Honorable Commission, on behalf of your various offices and bureaus, we present for your consideration and disposition the following agenda items, commencing this morning with matters on behalf of the Bureau of Audits. It is recommended that the Commission adopt the two recommendations on page 1 to release audit reports with regard to the PECO Energy Company's transmission service charge, as well as the PPL Electric Utilities Corporation Act 129 compliance rider.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to page 2 of the agenda and matters on behalf of the Office of Competitive Market Oversight, it is recommended that the Commission adopt the staff recommendation to adopt the advance notice of proposed rulemaking with regard to transferring customers' accounts from default service providers to competitive suppliers, from supplier to supplier, and from suppliers back to providers of last resort, as well as the ancillary regulatory changes and safeguards associated with that.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Powelson. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to matters presented on behalf of the Office of Special Assistants, commencing on page 3 of the public meeting agenda in omnibus fashion, it is recommended that the Commission adopt all of the items appearing on page 3 through and including the last item at the bottom pertaining to the Bureau of Investigation and Enforcement versus Nasser Limousine LLC.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Powelson, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? Motion passes 5-0.
On page 4 of the public meeting agenda, with regard to the formal complaint of Esther Lenzer versus Philadelphia Gas Works, Madam Chairman, there is your motion as well as the joint statement of Commissioners Coleman and Powelson.
Is there a motion to call up this matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Vice Chairman Place, who I will then turn over to preside.
Thank you, Chairman. I'd like to recognize Chairman Brown for the purposes of her motion. Chairman Brown.
Thank you. The initial decision of the Administrative Law Judge Cynthia Williams Fordham dismisses this case with prejudice due to the complainant's failure to appear at the hearing. The complainant filed exceptions to the dismissal of the case, explaining that a medical condition prevented her from appearing at the hearing. I believe that the medical condition, if verified, would serve as a justifiable excuse for permitting the complainant to file a second complaint on the same subject matter. Therefore, while I agree with the recommendation to dismiss the complaint, the dismissal should be without prejudice. Based on these unique facts in this case, dismissing without prejudice protects the complainant's right to due process while respecting the Commission's administrative process. Therefore, I move that the administrative law judge's initial decision be modified consistent with this motion, and that the Office of Special Assistance draft an opinion and order consistent with this motion.
Thank you. Having heard the motion, is there a second?
Second.
Seconded by Commissioner Sweet. Any discussion? Seeing, sorry.
Vice Chairman Place, Commissioner Powell and I have a joint statement that we'd like to have entered into the record as though we had read it in its entirety. And just briefly, what I'd like to comment on is we don't believe that the facts in this case warrant a departure from our practice of dismissing a complaint with prejudice when the complaint neither requests a continuance of the scheduled hearing nor makes a good faith attempt to attend the hearing. So we'll just simply state for the record and ask that it be included in the record in its entirety. Thank you.
Thank you, Commissioner Coleman. Any other discussion? All those in favor signify by saying aye.
Aye.
All those opposed?
Opposed?
Opposed.
The motion carries 3-2. Gavel's yours, Chairman.
Thank you. On the matter as amended by the motion, any further discussion? Hearing none, do we want to take the previous roll call? With hearing no objection, taking the previous roll call, the motion as amended passes 3-2, noting the dissent of Commissioner Coleman and Commissioner Powelson.
In omnibus fashion, it is recommended that the commission adopt the recommendations commencing with that in the middle of page 4 in the proceeding involving the Columbia Gas of Pennsylvania's petition for an increase in its DISC revenues. And the remaining item on page 4 pertaining to the Bureau of Investigation and Enforcement versus Mountain High Transportation Group, continuing the omnibus to include all items appearing on pages 5 and 6 through and including the recommendation with regard to the joint petition for interconnection of United Telephone Company of Pennsylvania, DBA CenturyLink, and Level 3 Communications, LLC.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second? Second. Motion by Commissioner Coleman, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
On behalf of the Bureau of Technical Utility Services, again in omnibus fashion, we recommend the adoption of the items commencing with that at the top of page 7 and the preceding designated electric generation supply and license cancellations, continuing with the remaining items on pages 7, 8, 9, 10, and 11 through and including the proceeding involving the application of PSCG Energy Solutions, LLC.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Powelson, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
On behalf of the Law Bureau, on page 12 of the public meeting agenda, it is recommended that the commission adopt the recommendation pertaining to the Duquesne Light Company petition for reconsideration, proposing an alternate meter testing plan, noting the joint statement, Madam Chairman, that you have along with Vice Chairman Place.
Is there a motion to adopt the staff recommendation?
So moved. Second.
Motion by Commissioner Powelson, second by Commissioner Coleman. Under discussion, I would recognize Vice Chairman Place for our joint statement.
Thank you, Chairman. And Madam Secretary, I ask that my statement be placed into the record as if I'd read it in its entirety. Before us today is Duquesne Light Company's petition for reconsideration of the Commission's June 23, 2016 order, which denied the company's request for waiver of certain meter testing regulations. Duquesne seeks reconsideration of our interpretation of the Commission's 2009 smart meter procurement and installation order and requests a waiver of section 57.20, subsection H, for an alternate testing plan. No answers were filed to the company's petition. At the time that Duquesne's petition for waiver was denied, we expressed our concern that the company had not adequately explained why broad public notice was not provided to its customers, given the importance of meter accuracy. We determined that there was not enough factual information to allow us to thoroughly consider how granting the requested waiver would affect rates. Thus, the Commission requested information on savings to ratepayers as well as responses to certain questions attached to the order, assuming that the company would file a revised petition for waiver. In its petition for reconsideration, Duquesne indicated that it would file the requested data as it relates to the waiver. At this time, the company has not filed the requested data with their petition for reconsideration, nor has it filed a revised petition for waiver, including the requested responses. We continue to find it necessary that the company provide the information to the Commission so that we are better able to assess Duquesne's argument of whether the waiver regarding the meter testing should be granted. We encourage Duquesne to file their arguments and additional information as the above captioned docket related to their smart meter procurement and installation plan. Thank you.
Thank you, Vice Chairman Place. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to matters on behalf of the Office of Administrative Law Judge, commencing on page 13 of the public meeting agenda. With regard to the first item pertaining to the application of UGI Utilities, Inc. Gas Division for the transfer of certain facilities to UGI Central Gas Control, LLC, as well as the approval of certain related affiliated interest agreements, there is the motion of Commissioner Sweet.
Is there a motion to call up this matter for consideration?
So moved.
Is there a second?
Second?
Motion by Commissioner Powelson, second by Commissioner Coleman. Under discussion, I would recognize Commissioner Sweet for his motion.
Thank you. I ask that my motion be placed upon the record in its entirety, but I will summarize it here. Before the Commission is an initial decision approving a joint petition for settlement between UGI's Gas Division and the Retail Energy Supply Association, RESA, in an application where UGI proposes to transfer certain gas control assets to UGI Central Gas Control, LLC, which was introduced as a newly formed subsidiary of UGI's affiliate, UGI Energy Services, LLC. The application has 3 affiliated interest agreements associated with it. The settlement between RESA and the applicant takes care of RESA's issues in this case, and I agree with approving those settlement paragraphs which reflect the resolution of the issues settled. However, the settlement does not fully address the application itself and the 3 accompanying affiliated interest agreement proposals, and is specifically lacking in a comprehensive technical evaluation of these matters. Therefore, I move that the initial decision of the administrative law judges be adopted insofar as it approves the joint petition for settlement paragraphs 11, 12, and 13. Secondly, that the application is amended by the joint settlement and the accompanying affiliated interest agreement proposals at these dockets be assigned to the Bureau of Technical Utility Services for further evaluation, consideration, and disposition. Third, that the Office of Special Assistance prepare an appropriate order.
Thank you. There's a motion of Commissioner Sweet. Is there a second to the motion?
So moved.
Is there a second by Vice Chairman Place? Any discussion on the motion? Hearing none. On the motion, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0 on the matter as amended by the motion of Commissioner Sweet. If there's no objection, we will take the previous roll call, and the matter as amended by the motion passes 5-0.
It is recommended that the Commission adopt ALJ Johnson's recommended decision adopting the settlement in the proceeding involving the Duquesne Light Company's petition for approval of its 8th default service plan, as well as the related affiliated interest transactions, noting your joint statement, Madam Chairman, along with Commissioner Sweet, the statement of Vice Chairman Place, as well as the joint statement of Commissioners Coleman and Powelson.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Under discussion, I would call on Vice Chairman Place for his statement.
Thank you, Chairman. Madam Secretary, I ask that my statement be placed in the record as if I'd read it in its entirety. For the Commission for consideration and disposition is the petition of Duquesne Light Company, the non-unanimous settlement petition, and the recommended decision of Administrative Law Judge Johnson for approval of Duquesne Light's 8th default service plan for the period June 1, 2017 through May 31st, 2021, as well as other approvals required for the implementation of the DSP-8. Upon review, I concur with ALJ Johnson's recommended decision to approve Duquesne's default service plan. Duquesne Light did not propose long-term contracts as a component of the prudent mixed procurement requirement. However, none of the parties to this proceeding argued that the petition, as modified by the settlement, failed to meet the prudent mixed standard. Moreover, it should be recognized that the supply portfolio for residential and small commercial customers represents an increase in longer-term hedges. Lastly, Duquesne has also noted its intent to enter into a long-term solar contract and to make a separate filing with this commission. In examining these proposed procurement plans, it is important to look at the totality of the supply components of these portfolios and their effects on competitive offers, price volatility, and most importantly, overall cost to consumers. I believe that the portfolio contained in the non-unanimous settlement petition meets that standard of review. At the same time, I encourage all electric distribution companies to address the prudent mix requirement more transparently in future default service proceedings. Additionally, while I support the proposed supply portfolios, I am concerned about the lack of competitive electric choice options for Customer Assistance Program participants, or CAP. Duquesne has noted that CAP shopping would not be permitted until their next default service plan filing, which is effective June of 2021. The company's IT system and potential for CAP design uncertainties were identified as reasons for this 5-year delay, as well as the company's proposal to hold a collaborative in the fall of 2018 to review other electric distribution companies' CAP shopping programs. The ability of consumers to shop for electricity is a hallmark of Pennsylvania's competitive markets, and the inability of these customers to shop comes at a cost not only to these individuals, but to the balance of the company's residential customers who support these programs. In seeking to provide energy burden relief for the most vulnerable populations, I strongly encourage the parties to expeditiously convene the proposed CAP participant shopping collaborative and to work aggressively to resolve the identified constraints as quickly and as prudently as possible. Thank you.
Thank you, Vice Chairman Place. I now recognize for further under discussion a joint statement of Commissioner Coleman and Commissioner Powelson. I will recognize Commissioner Powelson.
Thank you, Madam Chair. Before the commission this morning, as the Vice Chairman mentioned, is Duquesne Light Company's DSP filing. We believe that Duquesne's plan clearly satisfies the statutory requirements for default service procurement here this morning. In light of recent court decisions, we also want to use this opportunity to clarify how these requirements should be interpreted. Act 129 requires that default service providers acquire energy through a prudent mix of spot market purchases, short-term contracts, long-term purchase contracts. They're designed to address these 3 areas. One is to provide adequate and reliable service. The second, provide the least cost to customers over time. And third, achieve these results through competitive processes that include auctions and requests for proposals and bilateral agreements. When evaluating a particular default service plan, the Commission must consider the prudency of including each type of procurement method in the mix. In these determinations, the Commission may find that the Commission may find that it is prudent for a default service provider to include only one type of contract in its portfolio when that is the option most likely to produce the least cost over time. The Commonwealth Court has affirmed the Commission's approval of a spot market-only procurement approach by a default service provider as consistent with the mandates outlined in the provisions of Act 129. In fact, in the Popowski case, the court found that the Commission approval of default service providers' procurement method through a spot market purchase alone complied with the Act 129 prudent mix standard because the Commission properly considered the possibility of including short-term contracts in the procurement approach and determined that to do so would not be prudent. Specifically, the court found that the Commission's consideration of longer-term hedging contracts in that case would not be justified by additional costs to customers. It is important to note here this morning that in the Popowski case, the court found it significant that not even the Office of Consumer Advocate argued for the inclusion of long-term contracts in the default service provider's procurement approach to comply with the Act 129 prudent mix standard. As such, it is clear that neither the court nor OCA interpret the prudent mix standard to uniformly require the inclusion of long-term procurement contracts to comply with the Act 129 provisions. This interpretation confirms that it is within the jurisdiction or discretion of the Commission to determine that one or more procurement methods are prudent to ensure least cost to customers over time in light of the particular facts of each case. Based on the Commonwealth Court's interpretation of the statutory language of Act 129, we wish to highlight that Act 129 does not require the Commission to blindly require all default service providers to include spot market, short-term, and all long-term purchases in every procurement portfolio. Rather, the Commission is required to consider the prudency of including one or more types of these procurement products under the particular circumstances involved in each case to ensure that the products procured result in compliance with all the statutory requirements of Act 129, including least cost to customers over time. We caution that uniformly requiring all default service providers to include spot market, short-term, and long-term purchases in every default service proceeding will come at the expense of other Act 129 mandates to ensure that default service procurement is not only prudent, but also ensures adequate and reliable service to consumers at the least cost over time. Thank you.
Thank you, Commissioner Powson. Further under discussion, there is a joint statement of myself and Commissioner Sweet, and I would ask that our joint statement be placed upon the record in its entirety. I would do a brief summary of it. When looking at the decision, there's one important concern that we must raise, namely the lack of any new or grandfathered long-term contracts within Duquesne's proposed default service portfolio. In our opinion, this lack of any long-term contracts is a fatal flaw under Section 2807E of the Public Utility Code, which warrants our dissent in this proceeding. Case precedent on this issue is instructive, very instructive, matter of fact. In 2013, the Commonwealth Court ruled that the Commission acted within the bounds of Act 129 when the Commission approved Pike County Electric Company's 100% spot market procurement in a default service filing. However, the court also found that the Commission's approval of a spot market-only procurement in light of the prudent mix standard was lawful, since the Commission properly considered the possibility of including other contracts, including financial hedges, and determined it was not prudent to do so. We emphasize that our interpretation of Popowski is not that a default service portfolio must include long-term contracts. Let me emphasize that again. Our interpretation is not that it must include long-term contracts, rather that our reading is that a utility has the burden of proof of providing evidence justifying the omission of any type of contract enumerated in Section 2807E of the Public Utility Code, whether it's spot, short-term, or long-term. The record in this proceeding references the Commission's 2011 default service opinion. It is very instructive to review how the Commission further disposed of this issue in that 2011 order. The Commission stated, as we have done in other aspects of the plan review process, we will continue to review each plan on a case-by-case basis that independently evaluates the merits of each default service plan where input from stakeholders is assured. We reaffirm our commitment that a prudent mix include a combination of spot purchases, short, intermediate, and long-term contracts, recognizing the limitation of 25% on long-term contracts under Section 2807E 3.2, Roman numeral 3, too many Roman numerals. We do reject the positions of those parties that prudent mix be defined to always require a specific mix or percentage of types of contract components in each default service plan or a minimum of 2 types of products. We also reject the position that long-term contracts should not be part of the prudent mix standard. We submit that the policies set forth in the 2011 default service order of the Commission merely establish that there is no exact formula for the correct prudent mix. Rather, it is the responsibility of the utility on a case-by-case basis to show that its proposed portfolio of contracts complies with the requirements of the Public Utility Code. The 2013 Pike case established a further threshold that substantial evidence is required to deviate from the statutory requirements of Section 2807. Since the record in this proceeding does not provide substantial evidence supporting the omission of long-term contracts, we must respectfully dissent. You have heard all the discussion. Is there any further discussion? Hearing none. All those in favor of the motion to approve the Duquesne Light Default Service Plan, say aye.
Aye.
Any opposed?
No.
No. The motion passes 3-2, noting the dissent of Commissioner Sweet and my dissent as well.
With regard to the formal complaint proceeding of Jacqueline Fielder versus Verizon Pennsylvania LLC, there is the motion of Vice Chairman Place.
Is there a motion to call up this matter for consideration?
So moved.
Second.
Motion by Commissioner Coleman, second by Commissioner Powson. Under discussion, I would recognize Vice Chairman Place for his motion.
Thank you, Joan. Madam Secretary, I ask that my motion be placed in the record as I've read it in its entirety. Before us for disposition is the initial decision of Administrative Law Judge Elizabeth H. Barnes addressing the formal complaint of Ms. Jacqueline Fielder against Verizon Pennsylvania LLC. ALJ Barnes' initial decision largely agrees with the company's preliminary objections and dismisses the complaint on the basis that the complaint is not entitled to relief as a matter of law, and that there is no factual dispute that the complainant received VoIP services that the Commission lacks the authority to regulate. Although I agree with most of the reasoning and the result of the initial decision reaches, certain aspects of its discussion need some additional clarification. The initial decision largely and correctly utilizes the statutory provisions of Pennsylvania's VoIP Act of 2008 in its finding that the Commission cannot exercise jurisdiction over the VoIP service that is the subject of the complainant at issue. However, the initial decision also raises the inference that VoIP is an interstate service. I note that the VoIP Freedom Act of 2008 preserves Commission jurisdiction over VoIP services in a number of aspects, such as the provision of and administration of 911 service, I am struggling on this one. It's telco. The provision, I'll repeat myself. The provision of administration of 911 service, telecommunications relay services, universal service fund fees, switch network access rates, or other intercarrier compensation rates for inter-exchange services provided by the local exchange telecommunications company, and rates, terms, or conditions of protected services provided under tariffs subject to the approval of this Commission. The preservation of such Commission jurisdiction over VoIP services under applicable Pennsylvania and federal law would be legally impossible if such services were to be considered solely as interstate simply because they technically and functionally rely on the Internet protocol. The VoIP Freedom Act of 2008 did not intend and does not create such a legal conflict. Thus, I conclude that the dismissal of the complaint at issue is adequately justified on the basis of the 2008 Act alone. Therefore, I move that 1, the result of the initial decision dismissing the formal complaint is affirmed. 2, the initial decision should be clarified consistent with this motion. And 3, at last, the Office of Special Assistance prepare the appropriate order consistent with this motion. Thank you for your perseverance.
You have heard the motion of Vice Chairman Place. Is there a second?
Second.
You have heard the second of Commissioner Powson. Any discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0 on the matter as amended. If there is no objection, we will take the previous roll call. Hearing none, the motion passes 5-0.
Continuing, it should be noted on page 14 of the public meeting agenda that the matter identified as Kamikia Mayo versus Philadelphia Gas Works has been postponed until public meeting of January the 19th. That does conclude the presentation of regular agenda items. Turning now to the carrying agenda. With regard to the first item, on behalf of the Office of Executive Director Jan Freeman, it is recommended that the Commission ratify the appointment of Kelly Monahan to the position of Director of the Bureau of Audits.
You have heard the recommendation. Is there a motion to approve the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Powson. Under discussion, let me just say that We are happy to welcome Kelly Monahan to the commission. She joins us today in the audience, and we do ask her to stand up for a moment so that you can see her. Kelly is also joined here by her family, so we appreciate them coming with her for this acknowledgement here at the commission. Her knowledge and experience in audit issues and management operations will suit us well in her new position. Since 2005, Ms. Monahan has held various audit roles within the state, having worked in the former Department of Public Welfare and the Department of State, the executive offices within the Office of the Budget, and most recently at the Pennsylvania Department of Insurance. She received her Bachelor of Arts degree from Pennsylvania State University and a Master's of Business Administration in Accounting. So once again, we do welcome Kelly here. And on the motion, if there's no further discussion, all those in favor of ratification of the appointment of Kelly Monahan to the Bureau of Audit, say aye.
Aye.
Any opposed? The motion passes 5-0. Congratulations.
On behalf of the Office of Special Assistance, it is recommended that the commission adopt the recommendation at the bottom of page 1 in the matter involving the Bureau of Investigation and Enforcement versus Zex Towing and Recovery, LLC.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
On page 2 of the carrying agenda, continuing with matters on behalf of the Office of Special Assistance, it is recommended that the commission adopt the first item, which would grant reconsideration subject to further review of the merits of a petition for reconsideration involving Pico Energy Company's Default Service Plan 4. Should be noted that the next item has been postponed, that involving XO Holdings and Verizon Communications. And we would conclude with the recommendation involving NIAS, TA Saiva, Medical, Transportation, and the recommendation to reverse the administrative law judge in this proceeding.
Is there a motion to adopt staff recommendations?
So moved. Second.
Is there a motion by Vice Chairman Place, second by Commissioner Powelson? Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Continuing with carrying items to the final item appearing on page 3 of the carrying agenda, it is recommended on behalf of the Law Bureau that the commission adopt a proposed order in resolution of PPL Electric Utilities Corporation petition with regard to the continuation of online and automated interactive voice response system to establish payment arrangements.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Powelson. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Madam Chairman and Commissioners, that does complete the presentation of agenda items.
Thank you. Before we adjourn from our meeting, today the PUC is releasing the results of our annual cold weather survey, which provides a snapshot of the number of households across the state that are starting the winter without heat-related utility service, along with homes that may be depending on potentially unsafe heating sources. The survey is part of a wide-reaching effort by the Public Utility Commission to educate consumers about the many resources available to them to help them stay safe and warm. The key finding of this year's survey is that the situation across Pennsylvania continues to improve, which means that fewer households are starting the winter without heat, and fewer people are depending on potentially unsafe heating sources, but there's still a lot of work to be done. The focus for the PUC, along with the utilities and human service organizations across the state, is to help those families and individuals who are still struggling. First and foremost, if you or someone that you know is going without utility service or has received a shut-off notice, we emphasize that you call your utility as soon as possible and ask them about programs available to help customers in need. Utilities will work with you, explaining what programs may be available based on your situation. If you don't get a response from your utility or are unable to reach an agreement, we emphasize that you call the PUC's Bureau of Consumer Services for information at our 800 number, which is 800-692-7380. Additionally, many customers may also qualify for the LIHEAP program, the Low Income Home Energy Assistance Program, which is a federal assistance program administered by the Pennsylvania Department of Human Services. For more information about LIHEAP, check with your county assistance office or call the Pennsylvania Department of Human Services at 866-857-7095. This is important information for families who may already be struggling, and an equally important reminder for people who may encounter problems later this winter. Throughout the cold weather months, we will continue reaching out to consumers and continue working with our utilities and human service groups across the state to ensure that people get the support services that they need. Thank you. Also want to emphasize to you that our next public meeting, write this down, will be January 19th of 2017. And also with that announcement for our next public meeting, we would also like to note that beginning in January, in the interest of efficiency, the commission will no longer be distributing printed copies of our motions or statements after public meeting. Instead, you will be able to find them on the PUC's website. We know that this is the last public meeting of the year in December. We know that all of you are very much wanting to get out and finish all of your holiday shopping, but we do want to make sure that we wish you a happy holiday, whether it's Merry Christmas, Happy Hanukkah, Happy Kwanzaa, Happy New Year. Enjoy your holidays, be safe, and remember that our public meeting is on January 19th, the next one. So thank you very much. And the meeting, without objection, the meeting is adjourned.